Good afternoon, everyone. I'm your employment lawyer today, Darren Sall from Samfiru, Tumarkin. I'm in the Vancouver office. Pleasure to join you all here today. I'm here for the employment law Q&A, the half-hour Facebook and YouTube Live. Looking forward to answering all your employment law questions. Anything you have, employment or employment law related, any issues you're having with your current employer, past employer, future employer. Any questions you might have had relating to your employment contracts, terminations, or just employment in general. I'm here to answer all your questions. Don't be shy. Um, Wanted to just mention that I'm in the Vancouver office. We currently practice in BC, Alberta, and Ontario. If you guys have any questions, this is a great venue to get real-time answers to any of your employment law questions. You can also go to employmentlawyer.ca. That's our website. It's www.employmentlawyer.ca. And you can reach out to our handy intake team if you have any questions to set up a consultation with one of our lawyers in whatever province you live in within BC, Alberta, and Ontario. Um, so before we have some questions coming in, I know we don't have any questions right now. So while we're waiting for a couple questions to come in, I wanted to just have a quick chat about some interesting files and issues that have kind of come across my desk recently. One of which deals with, the most recent one had dealt with a concept called mitigation. And what that is in an employment law context, you will have a duty, and we got some questions coming in. I'll just finish this thought real quick, and then we'll hop to this. You'll have a duty to, once you're terminated, you have a duty to find new work. And what that does is that can impact the amount of severance you're owed. So generally speaking, it can be different for certain employment contracts, but generally speaking, when you lose your job or when you're terminated without cause or even with cause, you have an obligation to try to find new work. If you do find new work within that termination period, that severance period, your employer or your former employer generally gets a dollar for dollar credit for every dollar of income you earn during that period. Now, the caveat with this is you're not required to find any work. You're required to find work within your own field, comparable work in terms of pay, status, in terms of job title, job type. For example, if you are an IT professional, you're not required to go take a job as a Starbucks barista. You're not required to go work retail sales. You're required to look for a job in IT. And if you're something like a network administrator, you don't have to be, back coding or whatnot. You would take a job and you would look for jobs in network administration. So that's something for everyone to keep in the back of their mind. If you're ever facing a severance situation, call us immediately, and we can help guide you through that process. We can give you a little more detail with regards to mitigation and what you need to do. You can go to employmentlawyer.ca. We have blogs. We have handy articles written by some are by myself and by my colleagues, which may answer a lot of your questions and which go through a lot of these concepts and issues that you're going to face, when staring down the barrel of a termination or following a termination. Handy tips on what you can do, how to act, and what to keep in mind, and maybe how to address the situation. So we've got some questions coming in. I'm going to hop over here. The first question we have in from Facebook is from Roberta Gavin. Roberta asks, my employer ended my authorization to represent while I'm on disability. I'm a level 2 insurance agent. Is there anything I can do? So Roberta, I'm sorry, I don't fully understand your authorization to represent. I don't know exactly what that is and what impact that has on your employment. From what I can tell, I don't know if that means you've been terminated or if you just can't do certain things within your profession. So I may need some more information. If you have any issues with, it's required to conduct. So Roberta just replied, it's required to conduct insurance. So if you're on disability and you're not currently working, I don't know if that has the specific kind of impact of terminating your employment or dealing with your licensing requirements at all. I think we may have to deal with yours in a very specific manner. So I would suggest you maybe give us a call. You can go on our website and you can grab my contact information. I'm happy to chat with you or just contact our intake team. You can go to employmentlawyer.ca. There's a number of ways to contact us, including online forms you can fill in. And give us some more information on that. I think we have to do a bit of a dive as to how this actually would impact your employment or ability to return. Typically, if you're on disability, certain parts of your employment may be affected, but it may not affect you in terms of terminating your employment as you're currently on disability. So Roberta, contact us, give us some more information, and we will be able to at least suss out an answer for you and give you some clarity. I have a question coming in through YouTube from Bonbon Lewis. Bonbon asks, can part-timers collect EI? I am unionized and on leave from my hospital job because I won't take the shot. So Bonbon, I won't be able to speak to the union aspect of your question. EI, I mean, you have to contact Service Canada. We don't typically deal with EI. I don't practice in EI law. My understanding, as basic as it is with this, is that as long as you have enough insurable hours, you'll be able to collect. The fact that you're on leave from a hospital job because you won't take, when you say the shot, I'm assuming you mean the COVID vaccine. My understanding from Service Canada, and again, I don't know how up to date this is or if they're still enforcing this, is that if you are on a leave for refusal to take the COVID shot or COVID vaccine, then they will not provide you with EI. So your part-time status or status as a union worker may have nothing to do with this, but I would contact Service Canada directly. This won't have really much to do with your employer. And Roberta came back and you did send an email. Okay, perfect. Thanks for sending an email, Roberta. Someone will get back to you. We have a very quick turnaround time. And so, if someone doesn't get back to you within a day or two, which I'm sure that they will, feel free to reach out to me directly. My contact details are on the website. I'm happy to just have a quick call with you and chat about this. And so we have another question. I believe this one is through Reddit, perhaps, or from Mark on Facebook. So Mark says, my partner works in a women's shelter and has been working 60 plus hours a week. She has been told she's classified as a residential care worker and does not qualify for overtime pay. She does not live at the shelter. Can she still be classified as a residential care worker if she does not live in the workplace? So Mark, it's a great question. I'm not entirely certain what the requirements are to be classified as a residential care worker. I'd have to look into that and refresh my memory on that. If what you're saying in one of the requirements is that they live at the workplace or live in the workplace, then no, she would be misclassified, I would say, given that information. But if it's just that she's a care worker who works in residential settings, then that may be enough. A woman's shelter, I believe would be classed as a residential setting, given the fact that my understanding is most of the occupants live there for the period that they're there. And so that would likely qualify as a residence, I would assume. So I would say give us a call or have your partner give us a call, Mark, and any documents you have that relate to this, send them on over to us to review. Depending on what the classification actually says and what the classification actually is, that will really turn on whether or not she's entitled to her overtime. And so you can email your documents to help@employmentlawyer.ca along with your inquiry. I was just up on the title card in the corner of the screen there. So that's help@employmentlawyer.ca. Send your documents in with your inquiry, and one of our lawyers will get back to you about that, or get back to your partner, Mark, about that. And so we have a question through Facebook. JB James. JB asks, if someone was fired for non-compliance of the vaccine and received 2 weeks severance, but is now, after 6 months of applying for jobs in my field, still unable to find employment due to the continued medical discrimination of vaccine mandates employers are clinging to, is there grounds to sue? So I assume you'd be talking about suing your former employer for additional severance, JB, and that would really depend on a number of things. One, whether you signed a release document when you received that 2 weeks of severance. If you did sign a release document when you received severance, there is nothing you'd be able to do after that. Most releases, if not all, prohibit you from doing anything, and attacking releases is very difficult. Once you sign, you're essentially out of options. And so I always recommend for people, when they are discussing severance with their employer, run it over with an employment lawyer. Call us. No documentation signed. So if they simply just gave you your 2 week severance, JB, then I would say, get in touch with us. Let us see your employment contract. So the way severance works is, the one thing that can restrict the amount of severance you're entitled to is an employment contract. If you have an employment contract, and this goes for everybody, if you have an employment contract that has a termination provision in there, that may work to restrict the amount of severance you can be given. And so when we have questions like this, JB, I say, send us your contract, let us review it, because even if you have a clause in there that says you're only entitled to 2 weeks of severance, in many cases, those clauses can be broken. Those clauses can be attacked, and we can get you more severance. That's the bread and butter of what we do. We look at some of these clauses and we attack them, and we get you more than is mandated in your contract. So that it turns on the wording of the contract, and it's very specific. So I would say, JB, get in touch with us, send us a copy of your contract, book a consultation, and let's have a chat about that and see what we can do. To address kind of the second part of your question, when you talk about difficulty finding work. So there's a difference between mandates in employment that you're in currently and mandates being applied to, as a condition of new employment. So in our view, you can't mandate an employer can't mandate a vaccine for an existing employee. But when it comes to making it a condition of new employment at a new company, that is something that employers generally are able to do. They can say you must have these credentials to take this position, and in addition to that, you also must have the vaccine. So I can see how that would put you in a bit of a predicament with obtaining work following your termination, JB. But I would say, if you want to look to get additional severance, send us a copy of your contract, book a consultation, and we'll see whether there's any wiggle room there, and we can get you more. And so we have another question through Facebook here. We have G Senga. G asks, has there been any cases of people terminated for not taking the vaccine, gone through the courts? Do we have any precedent set? So currently, G, there's no cases that have gone through the courts. We don't have any precedent in the employment setting. There's been a number of labor decisions that have gone through, and that's in a union setting, and it's not directly applicable to us, but those have gone through, and most of those have been very fact-specific, but favorable to employers as far as implementing these vaccines. But again, they're in a union and labor setting. So if you search this, you may find some of those. They're not directly applicable to general employment settings. They're restricted to labor and union. There's different factors at play there. So no, to answer your question simply, no, there have been no cases that have gone through the court yet that we have decisions on. So we're still waiting for that. And that will be a big determination of what we can do with these cases moving forward once we get a few decisions in that realm. Okay, and so while we wait for some, so hopefully that answers your question, G and JB, hopefully that answers your question as well. While we wait for some more questions to come through, I'll go back and I'll talk a bit about mitigation, which is what I was talking about while we were waiting for some of the questions to come in. And so that's the obligation for you to find new work. And that ties into what JB's question was there when he's looking for other work. Part of the employer, part of your duty to mitigate is, and your employer getting the dollar for dollar credit is to reduce your damages, to reduce your losses. Like I said, it only has to be in the area of comparable work to what you were doing from the job you were terminated from. And the fact that you can't find work, for example, in JB's case, you have to make active efforts. That's the extent of it. You have to try to make active efforts to find work. So, I tell people when you get terminated, start doing online searches. Contact us first always so we can have a chat about it. We can help set you up for success in terms of your claim and in your future. But you do online searches, you can contact recruiting companies, but you only have to look again for comparable employment. That's very important. And if you don't, there have been cases where people have gone to trial. Whereas there's a case recently where an employee from, I think, Pacific Airways had severance reduced because their mitigation efforts were found to be lacking or wanting. And in many cases, if you just don't do anything and you claim, okay, this is my severance entitlement, maybe it's 6 months, maybe it's a year, maybe it's 2 years, and you just sit around and don't do anything, you may get an award for severance for, X period of time, but the court will take into account whether you attempted to mitigate. Okay, and that is the most important part here is you have to actively look for work. If you can prove that, it won't be held against you typically. As long as you are actively looking for work, that's what you need. If you don't find work, you can't guarantee you're going to find a job. As long as you're applying for comparable positions, there are probably tons of people doing the same thing. It's competition. It is what it is. But you have to just be able to prove that you are looking for work, looking for comparable work. If you don't, it can be held against you. It can reduce your severance if you proceed to a trial or even after a judgment, as what happens in some cases is they're appealed and mitigation is taken into further account and awards can be reduced. So you want to always make sure you take proper efforts to mitigate, and you can always call us and we can assist you with that. You want to have proper records. So keep a chart, keep a list, keep a history of internet searches, kind of list them down, keywords you're using, things like that can be very, very helpful to establish your claim, to protect your claim moving forward, and to really set you up for getting your full entitlements, because that's really what we're talking about here. We're talking about, what you're legally owed in terms of through legislation or through the common law, through legal precedent, what you're owed. According to the law. And we really just want to protect that and make sure that you get the most bang for your buck, giving your service to a company. And that's really what that's about. So, contact us even if you just have questions like that. Facebook, these sessions here with myself or any of my colleagues are always a great way to just get a bit of information to say, hey, this is what I've done for mitigation. Can I do more? We're always happy to have a chat about stuff like that. And so we have another question coming in through YouTube this time. We have Carrie Smith. Carrie asks, how can I deal with my employer trying to sue me for false accusation of defamation? They have said if I sign a severance package and apology/release, they will drop the charges. And so Carrie, it's a bit of a complicated question. I don't know what, in terms of the false accusation of defamation, I don't know what that would entail. On its face, if you see some risk with the defamation claim, it seems like from what you're saying, signing the severance package and apology and release may prevent them from suing you. I would get legal advice specific on that. I would get the documents and I would book a consultation. This is very, very fact specific. There are negative reviews online, Glassdoor, about them that they are pinning on me. Yeah, so Carrie, we don't specifically do defamation here. We've done it, and I've handled some of those claims. Some of my colleagues have as well. These are very, very fact specific scenarios. And we need to review the documents. We'd have to have a fairly in-depth conversation. It's a little too in-depth to get to here. We only have about 9.5 minutes left. So Carrie, I would say, please do get in contact with us. You can email help@employmentlawyer.ca. You can go to employmentlawyer.ca and get our contact information, book a consultation. And it seems like there's a defamation and termination issue going on here, and we're going to have to give some specific legal advice. We're going to have to drill down some of these issues a little further to make sure you're getting appropriate advice for what's going on, because when you're facing down the barrel of a lawsuit, it can be very serious. Legal fees can be incurred on your part, whether or not their accusations are correct. If they're making false accusations, it doesn't stop them from suing you, and it won't stop you from having to defend the claim. So I think reach out. Let's have a chat. Chat with myself or one of my colleagues as soon as you can. I'm assuming you're in BC, so make sure you're contacting us and discussing it with the right office. All right. And so we have another question through YouTube. Jack Ross says, "Thank you, Darren, for all you and your colleagues do." Not a problem. We're happy to do it, Jack. It's what we do. And this is just a way for us to reach more people, because really, employment is so integral to everyone's life. You should have as much information as you can. This is a key part of everyone's life. We spend more time at work than at home in most cases. And so you want to make sure you're adequately protected. And when you're investing so much of your life into something, you want to make sure if something goes awry and you're looking for something new, you're at least adequately compensated and appropriately compensated. So you say contractor. So Jack goes on to say contractor, 7 clients, BC. What is the income percentage threshold to be considered a dependent contractor? So Jack, great question. There's no set threshold. It's not that once you hit this amount, you're automatically a dependent contractor. There are a number of factors that come into play here. With dependent contractors, income percentage. So what percentage of your income? What I'm assuming you're asking is what percentage of your income is coming from a specific employer. It's got to be fairly high, right? It's got to be fairly high, because the other factors will add on. So such as, do you supply your own equipment? Can you reject work? Do you have a say in your hours? Can you just conduct work however you want? There's a number of indicia that we go through, kind of almost like a checklist. And it's not exhaustive. There are a lot of factors very specific to different types of employment that will lend more towards, independent contractor or dependent contractor. I can say with, a fair amount of certainty that most people who think they're in an independent contractor relationship are in fact either employees or dependent contractors. Income threshold is a very important factor, I would say. If you're getting 5% of your income from a certain employer, probably not going to be an employee or a dependent contractor. If you're hitting the 60, 75, 80% mark, you got a much better case. I would say if you're sitting 90 and above, that's great. You got a great argument on that point. But again, that's very fact specific. There are a number of factors that will have to be addressed when going through your specific employment situation. So Jack, get in touch with us. Get in touch with an employment lawyer. Contact our office, and let's drill down your situation. It seems like you have 7 clients, and the split will be important there. I think the split will be important. For example, if 6 of your clients are 10% of your income and the other one is 90%, you've got I would say you got a pretty good argument that you're a dependent contractor in that case for the one employer. If you're sitting at an equal spread between, not great. But we'd have to look at the other factors as well, and how we can build those into to maybe improve your case and see what we can come up with. All right. Hopefully we hear from you, Jack. Hopefully that answers your question to the best that I can do, without having more details as to your industry and what you do. But get in touch with us and let's go through that. And so we have a question on Facebook from Sue Barnes. Sue asks, where I work, my boss has installed cameras. My question, though, is that I found out there are speakers and he can listen to our conversations. Plus, as a customer, he has called others asking what is said because he can't hear the conversations. Is this legal? So, Sue, it really depends on, I think, where the cameras are installed. The speakers and whatnot is I'm not a privacy expert, but generally when it comes to this type of thing, if you're in a public domain and you're you're part of a conversation. I mean, you can record things. I'm assuming he's just listening in and watching. I don't know if there's recordings going on and if he uses these for disciplinary purposes or if it's just to check in. It also will depend on whether or not this is in your contract at all. Whether you were notified of this and whether there is in your contract that you've specifically agreed to this. If you've specifically agreed to it, then there's not much you can probably do at this point. If it's in a public area, you don't really have a reasonable expectation of privacy in that setting. I don't know that there'd be much you can do. If these are in private settings, places where you may have a reasonable expectation of privacy, for example, a bathroom or something like that. Obviously, in that case, there's legal issues. There's legal issues that will have to be dealt with in that sense. And you say as a customer, he's called others asking what is said because he can't hear the conversation. Calling in to ask questions, I don't think would be a massive issue. I think your biggest issue here is the cameras and the speakers. But I think generally, if they're in a open area and an open work area, then I don't know that there's much you'd be able to do. You'd want to contact a lawyer that specifically deals with privacy. We do have several at the firm. So contact us. You can ask to deal with one of our lawyers who has a privacy designation, who deals with privacy issues routinely. We have some in the BC office, and they'll be more than happy to speak with you. All right. Sorry, I couldn't give you more directed advice there, Sue. And we have some questions coming in off YouTube. A few here from Jay Muffalo. Jay asks, you fire the grievance while administrative leave. Can you file the grievance as well on administrative? So Jay Muffalo, I don't know. That grievances and administrative leave, that's a union context. That's not something I deal with. That's very specific. You'd want to talk to your union representative or shop steward about what the process and procedure is. It'll be dictated by your collective agreement as to the process and procedure for filing grievances for whatever union you're a part of. Sorry, we can't provide any advice on that, but contact your union rep and they'll be able to assist you. And so we have a question in from Facebook from Kim Pat. Can you refer to a lawyer that may take class action people versus MP DM, please? So Kim, I'm not quite sure what you're asking. I mean, we can do class actions. We've done class actions here. I've personally handled class actions in the past, and our firm does as well. So you can feel free to call in. It really would depend on the area of law. Depending on if it's an employment issue or not, then definitely give us a call. If it's something dealing with even product liability, we can assist with those things as well. Really just give us a call, 1-855-821-5900. The number's up in the corner of the screen there. Give us a call and give us some more information as to what you're looking at and what type of class action you want to discuss. And we'll be more than happy to talk to you, or we can potentially refer you out. There's also, if you Google the Canadian Bar Association Lawyer Referral Service, they can put you in touch with some class action lawyers as well. We have a question through Facebook from Nita. Nita asks, I'm on maternity leave and my position has been eliminated. When I go back in December, they don't have a plan for me when I return. What does the law require them to give me in terms of a position upon my return? My employer has indicated I would need to apply for a different job internally, but I don't see how it's my responsibility to find myself a new job. So, Nita, that's an interesting question. As you're returning, if they've eliminated your position, they owe you severance. Okay, if it's a genuine position elimination, they owe you severance when you return. They do have a duty to accommodate you upon your return from a maternity leave. They can't terminate you while you're on a leave. There is a duty for them to accommodate you. I think we need to know, I think we're out of time right now, unfortunately, but I think if you contact us, I'd love to have a chat with you. I think anyone else in the firm would as well. There's a couple details we'd want to get from you as far as what they've done so far, the terms of, how the position was eliminated, and what's going to happen with this internal job application process that they've proposed. And whether or not they've proposed any kind of severance to you. So contact us. I'm sorry, I think we have one or two other questions that came through we weren't able to answer today. We try to get through all of them. Thank you everyone for coming. Be sure to, like the post and to like this and subscribe. I'm back every 2 weeks. I have colleagues this week. Our next employment law Q&A session is with the employment lawyer himself, Mr. Lior Samfiru, on June 15th, and that will be 1 p.m. Eastern time. He's in Ontario, but he's knowledgeable about everywhere in Canada. So come in and don't be shy. Don't hesitate to ask any questions you have to any of us. All right. Thank you for joining me today. I hope to see you all in 2 weeks or to see new people as well. And thank you so much.